But since the organizers have provided for interpretation, I would like to thank them for this. And it's by saying thank you that I would like to start. I would like to thank the State Secretary for inviting me to this conference. And it's always a huge pleasure to me to return to Budapest, and it's always a pleasure to see my Hungarian friends. And by conference, we're getting closer to one another. And Aniko Rice has also mentioned this and raised the awareness that France is actually not in Central Europe. But I think we're all aware of this. You don't need to be very savvy in geography to know that. But what appears very interesting to me is the following. Well, first of all, if there's a French person we're asking about this context, it means that it could be actually a useful thing to do, because they will have a different perspective on something that is not their own, even if this kind of view of the things is not that enlightened, but it could still be of importance. And there is also another question that might be of importance. If we speak about constitutional identity, then this sort of identity is, of course, not a concept that would be that of Hungary or that of Central Europe. But what is very interesting is that the Hungarian standpoint regarding constitutional identity led to the fact that in many other countries, also in France, there is a wide-ranging debate about the question what constitutional identity actually means. So they put the emphasis on the national domain. And why, actually? Because this question about constitutional identity is a concept that is fundamental from various aspects. If it defines the relation of nation states to one another and defines also how the nation states look at the European Union and the European Council. So this is a concept that actually goes beyond the boundaries of Central Europe, even if it was Central Europe that was one of the focal points of these debates. As regards constitutional identity, this is a question that appears also in a national context in the wording of the Constitution, so in a legal text. And this is also something that is influenced by history, religion, and culture. So everything that can be found in the Constitution is actually summing up the identity of a nation. So if it is about a national identity, then this is something that is characteristic for people. This doesn't mean that there are values or principles connected with this identity that couldn't be shared with other sets of nations or groups of states. And one of the elements of this debate is the following. We need to be able to distinguish between what is characteristic and what is common. And what is also very interesting, and we need to highlight this especially, is that the question of national identity is actually a returning element in legal debate. At least it is in France. And in France we actually have less discussions about this until 10-15 years ago, because it appeared very natural. But actually these days it expresses some sort of resistance towards globalization. Firstly, it appears as if supranational would dominate above the national everywhere, and not only from an economic perspective or commercial perspective, but there's also this sort of cultural supranationality. And there's another question I would like to look into. The crisis of national identity is mostly a European crisis. It's a European question. And why is it so? Why is this phenomenon so European? Because this actually tackles questions that regard the relation between European structures and national structures, and they question the connection between the two. And this is why we actually touch upon national identity. Of course, there are other areas where this is affected, but this sort of system appears much less strongly over there. So let's see what happens in Europe when we speak about a political community. And already first grade law students learn that in law school, but whenever we teach about this, when there are people in a certain area that share a very similar political view, there is a sort of governance that appears, and then the state and the sovereignty appear. To this sovereignty and political community, we need to match the notion of border. Border is actually a line that gives a shape to a homogeneous community, and that also provides for some sort of protection against external forces. So we could say that the notion of the border could be something very obsolete these days and today. But if we think of migration or the Kosovo issue or the Crimea conflict, we can say that even the current situation proves that borders are still of a central importance. And if we return to the notion of nation and people, what can we see? The notion of people is not based on ethnicity, but someone would like to adhere to sort of historical project. And I don't want to go into detail about this, but we can see that when it comes to national thinking or the national concept, then this is a place where the law is actually the fruit of the history of the people, and the European construction goes against that. And that means that they say that law will create the people, and this is the Habermas way of thinking. And we need to ask ourselves the question whether law is actually able to create a people or shape a people. This is antagonism that could provide to many things an answer. And law, when we concentrate on law itself and we see its relation to national identity and supranational structures, then we can actually say that international and regional law, and this is something very important, is something that is created by supranational judges and applied by national judges. I would like to come back to this point because this is a very important question to me, because there's also a different area in which judges find themselves facing politicians. And what can we see here? The role of judges is getting stronger and the role of politicians is getting weaker. What is the main challenge here? It's a very practical question, and lawyers need to be able to find answers for this. There is, first of all, a sort of internationalization to which the states have adhered to, and they have also signed a contract in this regard. So, therefore, this has become binding for the states, and there are many obligations arising for the states from this. And the other question is how we could actually articulate constitutional identity, because if we don't take into account the existence of a national constitutional identity, then there would be no need for the existence of a state, because there would be no foundation for its existence. Logic might seem very simple, but it's very difficult to apply. So what we need to pay attention to is that the states shouldn't be faced with obligations that they haven't actually adhered to on their own voluntarily. And it's also very important that the states, when they have obligations, they need to fulfill these. That means that in Europe and within the European Union, there are mechanisms aiming at the compliance with the fundamental treaties, such as, for example, the Court of Justice of the European Union. And it's also very important that we need to be able to create limitations for the respective competencies. So for the national competencies, and what is something that the states actually consider as a joint competency. And it's very important to be able to protect these two sorts of identity. The problem actually hides in the fact that the national law, national constitutional law, and international law are not applicable for creating a hierarchy in norms. Because if we had this sort of hierarchy, then we would be in a federation, but we're not living in a federation. So it's very difficult to face this question. And this is exactly the reason why an opportunity arose for the judges to increase their power, because they are the ones that are responsible for the articulation of international law in a certain way. And as I've already said, that for us to be able to define these systems, we need the work of judges. And for this very reason, the power of political organization is weakening. And this is where I'd like to touch upon the Court of the European Union, which has the task, on the one hand, to protect European values and also to define where the room for maneuver can be actually found for the nations. So that means there's a certain agreement with the definition of which shows along which values they need to function. So, for example, it's very important that there's this sort of stalemate that we have here. There's an original text of an agreement which creates values for everyone. And the European Court of Justice, what do they have in mind? Well, they think in principles and questions that can be widely interpreted. So, in a democratic state, you need to comply with the legislation, you need to provide for openness and tolerance, and of course, these are very general, wide-ranging issues, but how can you concretely apply these and define them even further? So, between the European Court of Justice and the national courts, this sort of question is something that is subject to interpretation based on Article 2 of the Lisbon Treaty, and this actually broadens the competency of the European Union. And I'm not quite sure, at least I had the opportunity to talk to the members of the Constitutional Court back then. When the Constitutional Court looked at the wording of the Lisbon Treaty, Well, I think that many of them didn't realize that this Article 2 had a certain meaning, what it actually meant. They considered it as a very general, ornamental part of the treaty, and something that cannot be directly applicable about human dignity, freedom, democracy, equality, rule of law, respect of human rights, protection of minorities, tolerance, pluralism, justice, solidarity, equality between the sexes. So all of these things people agree with, and they didn't consider them as specific goals. But if you take a closer look at this question, then we can see that actually we can give a multifaceted content to these notions. So what does rule of law mean, for example? I think that this is about a very hard assimilation tool. What does it mean? We all agree that this also means that we need to protect the individual against forces and coercion. But what does it actually mean or bring about? This is something that is created from European values. But this is something that we could use for ideological concepts, for institutional questions, or about the question belonging to different gender groups. And what we can see is that especially the boundaries between the nations and the judges is very fluent, and we can say that this is about the independence of judges, but it doesn't necessarily mean the autonomy of judges. So there are many wide-ranging definitions we could actually apply even in this issue, such as, for example, in the European legal context, if this is what we take as the point of departure, then we could say that they are not assessing the question of rule of law as a principle to which all of the EU member states have adhered to, but as a notion that they want to apply in their own definition. So it's very interesting also to see how the European legislation and values and national values meet each other and relate to one another. So if we look at the question of constitutionality, in many cases the states recognize the national constitution as the highest level of legal text to which they adhere to. And this also means that if in every case we only apply this and we disregard our international obligations, that it will also mean that we are not necessarily complying with our international commitments. So it doesn't mean, it might mean that it doesn't make sense to conclude international contracts in this regard. But there are, of course, other situations where we have more details to the situation, and I won't really describe all of them, but there were cases where the Constitutional Court tried to solve issues in their own way. There's a Polish, German, Hungarian examples, but there's also the French one, or the Spanish, or the Italian example. What did we see? In France, for example, we were faced with two issues. The Court of Justice of the European Union regarding access to data and the number of working hours for soldiers were the two issues that we received as complaints from the Court of Justice, and that actually led to conflict quite clearly, and the court said that the French law didn't respect European laws, and the French responded that this is actually something that is part of the French constitutional identity. So this is the kind of resistance that was practiced there. And in Hungary there are also theoretical contradictions of a much higher level, which is also very interesting, and it also sheds light on many things. Is that there are so many contradictions that arise within a very short time frame. We can't say that the German or French legislation would like to go against Europe, but we can still see that there are difficulties arising. And in many cases, it might be under various forms, but our point of departure is the same issue. So we need to ask ourselves the question, what is the task of judges and lawyers? They're not politicians. They need to find out how they can actually solve certain situations. Neither I nor others will be able to solve this issue here and now. But let me just highlight some options. There's a clear situation of emergency that arises if we don't do anything. And if everything goes on the way it goes now, then we will end up with de facto federalism. And no one would actually assume about the European legal order that this is a federalistic one. But we see mechanisms evolving currently that carry some sort of federalist elements, and maybe citizens would actually revolt against this process if they had the impression that they are only spectators to these processes and not shaping these processes actively anymore. So that would mean that in a certain case that would actually entail the deconstruction of the European construction. So all of the political work needs to be done, and if this is what is required, then this kind of competency lies with the Council and not with the Commission, which is more of an administrative body, and it's not the task of the European Court of Justice either, because this is a legal organization. So when it comes to European construction, then it is quite clear that the competencies need to remain with the states, and this is also the competency of the Council. And this work needs to be done, and once it's done, then constitutional identity will provide a precondition already for the states to remain nation states. But there are certain areas in which the states have already transferred the competency to the European Union, and in this case it is very clear that the decisions lie with the European judges, and we need to be able to define this very clearly. What is the fundamental issue with this system? The European judge wants to decide about what is part of the European competency and what is part of the national competency. So this is a fundamental issue. And it's also an interesting question. We shouldn't talk about subordination, but we need to lead dialogues, and it's not very well functioning anymore between the European legal order and the national legal order. It's this sort of vertical structure. So we need to create different kinds of mechanisms. We are currently creating horizontal mechanisms, and I think it's very, very important right now, because the only efficient relation is the horizontal one. Because if we only look at things vertically, that would either lead to conflict, or the national identity will get dissolved in the current mechanisms. So national legal orders need to have the right to be able to ask questions, to question European legal decisions, in order to create solutions. And we can also think of a situation where a much more flexible system is created, such as, for example, to have a Supreme Court at the European level and at the national level, the members of which can gather together and assess the situation jointly. It's very important to create a more sustainable system, but let us not forget that it's not possible for a judge to take a final decision in a certain issue, because I think that the judge doesn't have the legitimacy to decide in a conflict of political nature. It's very important, therefore, to give back the final word and the option of the final decision to the political powers. And this means that we need to create dialogue between national and European levels of political context. What is the core of this issue? Currently, supranational logic found on a principle of national universalism and tries to operate a whole system on this basis. Where does this take us? This takes us to individualism, and we are creating spaces within society that disregard traditions, customs, history, and mentality of peoples. They deprive them of their common history and from the opportunity to work along joint projects. If some of these structures contributed to maintaining these structures, then still sometimes these goals can be very artificial, and if it is artificial, it is not sustainable. So thank you very much for your attention.